So a really interesting motion was just filed in the Matt Hoover CRS firearms prosecution, which aims to declare the NFA unconstitutional and therefore dismantle it. So let's talk about this. But real quick before we jump into this video, if you think the NFA needs to be repealed and done away with, go ahead and hit that like button and subscribe. So I guess in the intro, a motion was just filed in the criminal prosecution case, which involves the ATF going after Matt Hoover from CRS Firearms. This is a supplemental motion to dismiss the case against Matt Hoover, but also what it's trying to do is it also seeks to declare the NFA unconstitutional. It wants this district judge to declare the NFA unconstitutional under recent Supreme Court rulings. Now, we have talked about this in the past, but some of you might not know what's going on in this case or may not remember, so let me explain real quick. So Matt Hoover is a YouTuber known for his YouTube channel CRS Firearms. Earlier this year, he was arrested and charged with 8 various counts, ranging from conspiracy to transfer machine gun conversion devices and aiding and abetting in the transfer and sale of machine gun conversion devices in violation of the NFA. Matt Hoover was dragged into this case by the ATF because he created and posted videos on his channel in which he promoted the sale of the auto key cards. Because of this promotion on his channel, Auto Key Card received sales, and some of those sales came from Matt. And then in reaction, Matt also received sponsorship money and other items of value. And this is all according to the indictment. So that is kind of the basics surrounding this case and how Matt got dragged into this lawsuit. Well, in his case, he just filed a motion to dismiss the actions against him and also to have the NFA declared unconstitutional in light of the recent Supreme Court ruling in New York State Rifle and Pistol Association v. Bruen. The first section of this motion states, Bruen held as unconstitutional New York's 1911 Sullivan Act, requiring a license and demonstration of proper cause for the possession and carrying of a concealable firearm. What makes Bruen particularly germane to this instant matter is the announcement of a clear legal standard for the evaluation of acts regulating the peaceable keeping and bearing of arms. Bruen identified the Court of Appeals coalescing around a 2-step framework for analyzing Second Amendment challenges that combines history with means and scrutiny. The court correctly identified this as one step too many. Those previous decisions at the various courts of appeals manifested deference to the government in a manner unlike any other fundamental right, and the inexplicable consideration of regulations clearly contemplating the keeping and bearing of arms as beyond the scope of the Second Amendment. Finally, though, we have a standard which clearly articulates the burdens in a case involving restrictions on the right to keep and bear arms. It is as artfully penned by the court, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Here in the motion, they are pointing out the drastic change that the Bruen decision has created. The Supreme Court rejected the 2-step approach and instead reaffirmed text as informed by history as the standard when you look at the Second Amendment and these types of various violations. A government regulation can be upheld only if it has some historical analog or basis that actually supports it. And also, very important, that history must be rooted in the time around the adoption of the Bill of Rights. The government cannot support their regulation through a showing of new history or new laws, but instead they must point to founding era history and regulations. The motion goes on to state defendant is charged under 18 U.S.C. 5861 and 5871, as well as conspiracy to commit those offenses. The charged statutes deal with the taxation and transfer of machine guns and other weapons. The government alleges the tchotchkes at issue, the auto key cards, to be machine guns. What's more, actions subsequent to the passage of the charged firearm statutes render it impossible to comply with the taxing provisions, thus leaving the statutes a bizarre, vestigial area of law passed pursuant to the taxing power which, in dubious constitutionality, is used by the government as an independent, effective prohibition on the sale, transfer, or possession of any controlled devices not registered in 1986. The government may attempt to argue that machine guns are beyond the scope of the Second Amendment by attempting to characterize them as dangerous and unusual, as it has in other cases, but this is not the test. The court's invocation of dangerous and unusual weapons in Heller and subsequently Bruen was for the purpose of discussion of what might be in a constitutionally acceptable law rather than the endorsement of any particular policy. Furthermore, the question of whether a weapon is in common use at the time necessarily pins the analysis to the time before the prohibition. To consider otherwise would incentivize the government to legislate wantonly and aggressively, seizing arms, then later evade constitutional scrutiny by suggesting that the arms cannot be in common use because the government prohibited them. Such circular logic would be inconsistent with any fundamental rights jurisprudence. Thus, the government has the burden to prove that the regime in question is consistent with the history and tradition of firearms regulation in this country around the founding era. Now, what was just mentioned in that section is something very important that I want to emphasize. Often states like California try to argue that an arm is not in common use. For example, California made this argument in the magazine ban cases and also in the assault weapons ban cases. They tried to say that items are not in common use in the state of California, but really that was only because they put in place those bans on those items. Even a determination of something being dangerous and unusual does not give the government carte blanche to just ban items outright however they want. It only means that if they can establish something is dangerous and unusual, that they may be able to ban that item, but they still have to prove that their ban has some sort of historical basis or has a regulation that is analogous in history. This motion goes on to state, it is no great secret that no federal regulation of firearms existed before the enactment of these laws here at issue. In addition to the previously raised constitutional questions, nothing in the applicable history and tradition of the United States supports the categorical ban of machine guns, much less the item here at issue. Our nation's history and tradition does not and cannot support a finding that an alleged drawing of a part is that part merely because an unelected bureaucrat unilaterally willed it to be. They then point out in the motion legislative hearings surrounding the creation of the NFA and how even at the time when they were discussing this NFA, when they were discussing putting it in place, there was clear discussion and concerns about how an outright ban on machine guns would create a serious constitutional problem. The point being that even in 1934, they understood there was no real historical basis or support for this type of ban and that it would run afoul of the Second Amendment. The motion then closes out by saying, in the alternative to the advanced above, the application of section 5861 and 5871 is unconstitutional as it applies to defendant. Even if the government could somehow prove to the court that the wholesale felonization of the peaceable possession of an entire category of arms to be consistent, this case presents something far more peculiar, an administrative agency's unilateral declaration that an alleged drawing of a component the possession of which subjects the holder to lengthy prison time, is the component in itself. The underlying laws have evaded meaningful scrutiny despite being unprecedented in their severity, and the application thereof to defendant Hoover, a patriotic American and father who stands accused of talking about a piece of metal with lines drawn on it, and faces the complete destruction of his life and livelihood therefrom, demonstrates the severity with which this matter warrants meaningful constitutional review. The standard announced in Bruen gives the court the tools it needs to do so. Wherefore, defendant Matt Hoover respectfully moves this honorable court to dismiss the indictment against him in its entirety with prejudice, to declare the National Firearms Act facially unconstitutional, or in the alternative, unconstitutional as applied to defendant, and for any further relief that the court deems just and proper. Signed by his attorneys Zachary Zerme and Matthew LaRochier from Fudbusters himself. So now after hearing the motion, you might think to yourself, well, that sounds good, but what are the chances that through this motion, the NFA will be repealed and will be done away with? Well, under the Bruen test, my opinion is that these are all valid claims that are being brought in this motion. And yes, in my opinion, the NFA would fail the Bruen test. But the larger question is, if a court like the district court here will be even willing to go that far in a case like this. That is a big step and a big ask of a district court judge to essentially rule that yes, the NFA violates the Second Amendment. To me, this is one of those Hail Mary motions and throw everything you can at a case motion, and I appreciate they're doing everything they can to try to get these charges removed from Matt. Strategically, this is interesting because you take a case from an isolated ATF action against one individual to a larger and broader challenge to the NFA itself as invalid under the recent Supreme Court precedent. And maybe it's because of this motion, even if it's denied, this case eventually works its way up to the circuit court and then to the Supreme Court. And really it's these types of cases with weird fact patterns, interesting procedural makeup, and big questions involving things like the NFA that often entice the Supreme Court to finally take them up and review. These are the type of really weird and interesting cases with big issues that the Supreme Court likes to look at. So I highly recommend you guys go support Matt from CRS Firearms. Head over to his YouTube channel, and also he has a Give, Send, Go that's available. All you have to do is Google it and you can find that Give, Send, Go. Please support him however you can because again, these lawsuits are not cheap and he is still at risk of serious criminal prosecution because of this ATF overreach. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who liked, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.